and draft a clause which talks about, this is about the dispute, that 30 days must be given to rectify the dispute, failing which it will be decided by arbitration. Now, how is this going to be different from your single bank loan agreement? So first and foremost, this is going to be with multiple banks, and often this is a foreign, your syndicate loans often involve multiple foreign banks. It could have a combination of an Indian bank and a foreign bank also. If it's if foreign banks are involved, it will be a foreign currency loan. It will be falling under RBI's external commercial borrowing regulations. Under the ECB regulations, there are certain compliances to be followed and certain checks. So let's look at this. RBI is concerned with the amount of money that goes out of India, right? So RBI will prescribe a ceiling on the amount of interest that is payable. That ceiling is LIBOR plus certain amount of basis points. 100 basis points constitute a percentage. So 350 basis points is 3.5%. So if RBI says it's LIBOR plus 350 basis points, it means it's LIBOR plus 3.5%. What is LIBOR? LIBOR is an interest rate which is offered by banks in the interbank market in London. So banks keep on giving loans to each other from time to time for short duration. So for those loans also they charge an interest rate. That is an institutional rate and is much cheaper than a commercial rate. So what RBI does is it provides a margin or a spread, it's called. Spread means it's additional amount. So LIBOR plus 3.5%, that is what the spread becomes. In case it is 3.5%, the limit. What else you have to check under the ECB regulations? You have to check whether RBI approval is needed or whether it falls under automatic route. ECB regulations have certain sectors under which you can take under automatic route, like software. So manufacturing, software, hotels and hospitality industry, there it is possible to take these loans under automatic route. Okay, so there no RBI permission is required, but a loan registration number will be required and a form filing will have to be made to the bank for whenever the loan is taken. Okay, then there will be considerations of security also. Security, any secured assets offered in favor of offshore lender will require some kind of Indian bank, Indian authorized dealer alignment. Okay, these kind of terms are there. So it's not an approval, it is an authorized dealer bank in India may have to give some certification. Anyway, this exercise doesn't require you to get into that, but do remember this, okay? Second is that when there's a syndicate loan agreement, the problem becomes how do you actually call. So there are many actions like event of default. Okay, now event of default doesn't automatically happen. It needs to be called by someone. That some bank has to say this is an event of default. Or material adverse change has happened. Okay, now who will claim that this is an event of default? This is a material adverse effect. So the bank can do that. When there are multiple banks, you will have to have either a majority of them or somebody known as a security trustee who will act for the majority of them. Or the banks can have an agent who is a party to your syndicate loan agreement itself. So he will say that the agent will call. When more than 50% of the lending ratio of banks claim that there's a material adverse effect, then the agent will declare this. You can have a different rule. You can have a rule which says that if only one bank says so, even then an event of default or a material adverse effect can be called. You can have all these rules. So in a syndicate loan agreement, these are multiple banks lending through the same instrument. So they will have to coordinate because the rights are common in a way. So you are not splicing the loans separately, you are actually having common rights. So that will have to be done. There are also provisions for assignment of a portion of the bank's loan to another bank. So a bank can get off the loan and transfer the loan to another bank. I'll show you one second. I'll show you the syndicate loan agreement format. Syndicate loan and consortium loan, yes, it is similar, Shivam. And commercially, the syndicate loan is more commonly a terminology used. Consortium is usually used when there's a joint venture or when you create a group to bid for a tender, then you call it a consortium. but otherwise syndicate loan actually means the same commercial. Okay, so this is the syndicate loan agreement. It is 82 pages. It is downloadable. One thing that's great is it has a table of contents here. So there is something called an Asia Pacific Loan Market Association, which basically means all the institutions which have been lending have formed an association for the purpose of regularizing and standardizing the documentation. So now when law firms and banks work and give loans, they will follow the standard documentation and tweak it only to a minor extent. Like the broad structure of the entire document will be the same. They will tweak some aspects only. So see, the index actually explains every clause and how it's to be, what it means, and then you can quickly jump to the clause and see what is the meaning of that clause. Financial covenants are mentioned here, events of default are mentioned, changes to the lenders. This is something unique about syndicate loan agreements. Finance parties, role of agent and arranger. So a lot of times when you need a big loan, there will be an agent or an arranger who will help you for in compiling the loan. So he'll get the banks together, and then the arranger will have the banks commit to a certain amount, and the arranger will sort of ensure that the whole package adds up to the amount you want. Then there are payment mechanics and stuff. So this becomes a very long agreement, and it's like a shareholders agreement. There are conditions, precedent clauses, and transfer certificate is for transferring the share of the bank in the loan. And then there's a list of lenders, because lenders can keep changing. So you can even put lender's name in the schedule. And in the parties clause, you will write lenders as mentioned in schedule 1. Like that also you can write. Here name of lenders is not written. You can just write the lenders as a class also in the parties clause.